Welcome to Voices of Experience. In the next half hour, we'll be looking at a critical concern to Minnesotans as we consider significant changes to our system of voting. Quite literally, we have justice in peril as we examine the voter restriction amendment, which is popularly called photo ID. Retired Associate Justice of the Court of Appeals, Jack Davies, recently wrote that election law is complicated and fluid. We constantly find ways to make voting less expensive and more convenient. For example, in Minnesota, several rural counties have changed voting procedures, with voting now being done entirely by mail. And another example, Election Day registration has been in place in Minnesota for 4 decades. 41% of current Minnesotans registered to vote for the first time on an election day. Now, this whole system, as we look at 2012, this whole nature of election law in Minnesota is in peril. Joining us today to discuss vital voting issues in Minnesota is Justice Paul H. Anderson of the Minnesota Supreme Court. By way of background, I should mention that Justice Anderson was the Chief Judge of the Minnesota Court of Appeals from 1992 to 1994 and is currently an Associate Justice of the Supreme Court, having begun in 1994 and continuing to the present. Justice Paul Anderson, welcome back to Voices of Experience.
Dan, it's a pleasure to be back, but I think we owe the audience some full disclosure here, is that you and I go back a long way, don't we?
Absolutely.
We were at McAllister College together in the 1960s, early 1960s, and we've continued the friendship over the years. And I got to say one other thing, okay, about coming on your show. It's like that line in the movie Jerry Maguire that Renee Zellweger said, "You asked me to come on and you were going to explain all the reasons. I finally said, stop, Dan. You had me with hello. It's based on our friendship. I'm here."
Thank you so much. And I'm glad you clarified it was the 1960s. We were in college and not the 1860s.
Yes.
Okay. Now let's talk about the voter amendment that's on the ballot. How did we get to this point? How did the how come we are voting on a major change? What has happened? How did the language get to the ballot box?
Now, first of all, I got to tell you is that I'm going to tell you about the amendment process. I'm not taking any position on the amendments one way or the other, but it's important that we talk about the amendment process. And by the way, you said we weren't in college in the 1860s, but to understand the process, you have to go back to that time. You have to go back to 1857. As I said in my dissent, is when the Constitution was drafted, is that the Republicans and the Democrats were at each other's throat. They couldn't agree that we actually had 2 constitutions.
Yep.
And it came down to 3 key issues. It came down to where the capital was. The Republicans wanted in St. Peter, the Democrats in St. Paul. And it came down to Negro suffrage. The Republicans wanted to give the vote to the Negroes, and I use the term Negroes as the way it was used at the time. The Democrats did not. And it came down to redistricting for legislative, congressional, and judicial districts. The Republicans caved on all 3 issues, but they got one thing: easy amendment to the Constitution. We have one of the easier processes to amend our Constitution. The governor is not a party to the process. All you need is a majority vote in the House, a majority vote in the Senate, and you can put an amendment on the ballot. Some states require that vote occur in 2 successive sessions, but Minnesota has a relatively easy process to put an amendment on the ballot.
And is it a yes or no vote on the amendment? It seems to me there's a little catch to the number of yes votes versus the number of no votes.
Yes. The one thing is that it's a yes or no vote on the amendment, and I hope we get into the discussion of what's actually on the ballot. But it's a yes or no vote. But if somebody doesn't vote, that constitutes a no vote, because it has to be a yes vote for the majority of the people voting in the election.
Okay. Now, Justice Anderson, I'm going to ask you a very basic question. Who has the power to amend the Constitution of Minnesota? The people or the legislature?
It's the people, very clearly. I mean, and we were kind of going back and forth a little on, and you were repeating the preamble. And the preamble says, "We the people." See, this is what I get passionate about, that we live in a constitutional democracy. And the most fundamental document we have in this constitutional democracy governed by the rule of law are our constitutions, the U.S. Constitution and the Minnesota Constitution. And it's not like, the Constitution is not like ordinary law, which is subject to change almost, it can be annually, semi-annually, whatever. What's in the Constitution is supposed to be more fundamental. Can I give you an example?
Please.
Is that, and I said it in my dissent, is the Constitution is to be fundamental and basic and survive from generation to generation. Hamilton talked about the need to be protected from the ill humors that may emerge from the people themselves. He knew that you could have majorities that are subject to subjugating the minorities or taking particular advantage of their current majority. De Tocqueville talked about that, and it's about how the protection. So what we do as a people, and I'm going to go back to Greek mythology and literature, we're like Ulysses. We tie ourselves to the Constitution, so we are not drawn onto the shoals of destruction of our system of government by the siren call of any particular majority. So that's why it's so critical that people are careful about how they amend their Constitution.
Now, before we delve into this further, I want you to know, and our viewers to know, the position of afl-cio in Minnesota and the State Retiree Council. We are urging a no vote on this constitutional amendment for three reasons. One, it's unnecessary. We don't have voter fraud in Minnesota. We have close elections. We've had two very close elections, the last couple of election cycles. Voter fraud, no. Secondly, afl-cio views this proposed amendment as extreme. There are numerous hurdles put in front of voters, particularly seniors. There are other groups of people, other classes of people who are also affected. I'll be mentioning those later. And thirdly, this constitutional amendment, it's going to be very expensive. I've seen figures starting at $33 million, going to $50 million. Governor Arne Carlson mentioned $100 million in a public debate a few days ago. Local government will be forced to implement this unfunded mandate upon local government, this unfunded mandate coming from the state of Minnesota. So those are three basic reasons why Minnesota afl-cio has this position. And I want you to know that
this is your
position.
Commercial break, right?
Yeah.
I mean, I thought this was non-commercial. Your chance that, and let me comment on it. I mean, this is what you said. I have to respond. I tell you, I can't and I won't take any public position on the amendments. But in my dissent, I talked about, the court has rendered its decision. I talked about what happens next. And I quoted Thomas Jefferson, and I think it was very important, where he said, "I know no safe depository of the ultimate powers of society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is to take the vote from them, but to inform their discretion." And see, that's why I'm on your show. That's what you're about. You're fulfilling the Jeffersonian mandate that the people need to be educated so they can cast a wise vote. And that was part of the reason why I dissented. Well, it's unequivocal in my mind the legislature has the ability to propose the language of amendment. I came to the conclusion that the voter amendment, by the way, the ID amendment, or the marriage amendment, the full text is going to be on the ballot. The people can read what's going into the Constitution. So I don't have a problem with, maybe with the title, but I don't have a problem. The people can see what's going into the Constitution. The difference on the voter ID amendment, they will not be able to see what language is going into the Constitution when they go into the voting booth. And I ultimately came to the conclusion that the description that's being placed on the ballot instead of the full text is inaccurate. It's misleading. I started with the belief maybe it was possibly deceptive, but at the end of my opinion, I came to the conclusion it's not only misleading, inaccurate, but it's also deceptive. And that's what bothered me about, see, well, in June I was in Libya and Tunisia. I was talking about voting and voting fraud. In February of 2010, I was in Philippines working on their election process. Before the 2010 election, I met with a number of representatives around the world who were here to observe our election, talking about election, the elimination of fraud. And this is not an issue that I come to recently. And I have a certain amount of passion. And I've had so many people from other countries say, we want to be like Minnesota. But I'm worried that we might do something here that affects what's so special about us.
In the Supreme Court case that was decided last summer by the Minnesota Supreme Court case, you mentioned a couple times your dissenting opinion. The majority of the court ruled by a vote of 4-2 on the challenge that was brought by the League of Women Voters and others to how the amendment would be on the ballot, because the League of Women Voters felt it was inadequate, and the other groups. And you were one of two.
Yes, Justice Page and I both wrote separate dissents.
Yeah, and in the majority, there is reference that the wording on the ballot is close enough. Now, is close enough good enough for the people of the state of Minnesota?
Well, according to the majority, it is. And in my opinion, I said, when you're talking about the most fundamental basic law in a constitutional democracy, close enough is not good enough. I even say is that when you have the definition of close enough to incorporate something that's admittedly, even the majority admitted, inaccurate and likely misleading, and I said deceptive, that's not good enough. Close may count in horseshoe, but it should not count, to my mind, when you're coming to amending a constitution.
As afl-cio reaches out to its members, and we're doing that through telephoning, union retirees are calling union retirees, active union people are calling other active union people. One of the things that, and we don't just say, hello, vote no. Have you heard of the amendment? What do you have some questions on it? Do you have an opinion on it? And then we start to engage in a conversation. And it boils down, we tell people, you're being asked to vote in 2012 and to find out the details in 2013. The details will be coming out through the next legislative